10 racconti di solidarietà e aiuto concreto. Storie ricche d'amore, riscatto, coraggio e cura. Storie di persone che donano e che ispirano a costruire una società inclusiva. Una mano a chi sostiene. Storie.
Il senso religioso o l'esperienza religiosa è innanzitutto un fatto, un fenomeno obiettivo, un fatto reale, non è un'idea, innanzitutto non è un modo di sentire, non solo si tratta di un fatto, di un avvenimento, ma del fatto più imponente e più inestirpabile della storia dell'uomo. Più imponente, più vasto, che neanche il fenomeno dell'amore dell'uomo e della donna, che neanche il fenomeno del rapporto tra genitori e figli. Perché il senso religioso è un avvenimento che pone, che afferma o che ricerca l'orizzonte entro il quale acquisti senso anche il rapporto tra l'uomo e la donna, anche il rapporto tra genitori e figli. Perciò è più vasto, perfino di quelli.
Quello che ti serve quando ti serve. Come il piano Easy Smart a canone zero, anziché a 3,90 € al mese. Easy Bank, semplicemente banca.
A una O che divide, preferiamo una E che unisce. Per sostenere il presente e il domani di tutto il paese. E lo facciamo da 70 anni. Eni, l'energia di sempre e l'energia nuova.
10 racconti di solidarietà e aiuto concreto. Storie ricche d'amore, riscatto, coraggio e cura. Storie di persone che donano e che ispirano a costruire una società inclusiva. Una mano a chi sostiene. Storie.
Il senso religioso o l'esperienza religiosa è innanzitutto un fatto, un fenomeno obiettivo, un fatto reale, non è un'idea, innanzitutto non è un modo di sentire, non solo si tratta di un fatto, di un avvenimento, ma del fatto più imponente e più inestirpabile della storia dell'uomo. Più imponente, più vasto, che neanche il fenomeno dell'amore dell'uomo e della donna, che neanche il fenomeno del rapporto tra genitori e figli. Perché il senso religioso è un avvenimento che pone, che afferma o che ricerca l'orizzonte entro il quale acquisti senso anche il rapporto tra l'uomo e la donna, anche il rapporto tra genitori e figli. Perciò è più vasto, perfino di quelli.
Quello che ti serve quando ti serve. Come il piano Easy Smart a canone zero, anziché a 3,90 € al mese. Easy Bank, semplicemente banca.
A una O che divide, preferiamo una E che unisce. per sostenere il presente e il domani di tutto il Paese. E lo facciamo da 70 anni. Eni, l'energia di sempre e l'energia nuova.
Da un'idea di Giorgio Vittadini, un laboratorio di ricerca, formazione, divulgazione per promuovere la cultura della sussidiarietà, motore di democrazia e sviluppo sostenibile. Fondazione per la sussidiarietà, da 20 anni, un network che crea consapevolezza e partecipazione per il bene comune.
Civiltà dell'amore, fratelli e sorelle, costruite senza stancarvi mai questa civiltà. Lavorate per questo, pregate per questo, soffrite per questo. Buongiorno.
Good morning. It is an honor for us to have with us the President of the Italian Constitutional Court, Silvana Sciarra. A big applause for her. The topic we're going to address is at the very center of this year's edition of the meeting, which is work. The title of this session is Work at the Center of Democracy. We're going to make reference to Article 1 of the Italian Constitution. You probably know that Silvana Sciarra is President of the Constitutional Court, but at the same time she is an expert of work-related issues in constitutional terms. I'd like to make some introductory remarks of her speech so that we can contextualize her speech within the framework of this year's edition of the meeting. Yesterday there was a session devoted to work and a talk on generation work. On that occasion, a study with Randstad was presented. And the study shows very interesting data. That is to say, Italian businesses are currently investing in a new way of understanding work. They're investing in people who should no longer be equipped with competencies, but they also have to have the so-called soft skills. So the ability of looking at reality, of being empathetic, of being motivated. 3 graduates out of 4 find a job relatively soon. Many of them, come from universities who are capable of training them. And this is the good news. This is the interesting news that testifies to an actual change of the work labor. However, we also have to talk about the bad news. This type of training also tells us a lot that we need more training. We need to learn more. Working becomes easier. So finding a job today becomes easier if people are increasingly trained, if they have higher and higher levels of education. And from this point of view, we have a few problems in Italy. In Italy, the number of graduates and holders of secondary school certificates is lower to that of other European countries. In 2022, only 63% of the population between 25 and 64 years of age has a secondary school certificate, and only 20% are graduates, and the average in Europe is 34.4%. Then there are many young people who are finding difficulties. For example, the information concerning NEET, 1.7 million people between 19 and 25 years of age do not work, and 44% of people in the same age bracket are in a context of deprivation, which is even worse when we consider the fact that equality is our common objective. So if you are born in a poor family, well, you're going to be faced with the very first obstacle as a young person. Only 1/3 of the adults who are at risk of poverty, when they were 14, they lived in a family that was in precarious conditions. So coming from poor families means that you're going to have more difficulties in getting a diploma or a degree. So, and this situation will be difficult, for example, also for public debt. So the public expenditure in education went down. Conversely, Far Eastern countries, the countries are the countries which invested the most in education and in quality education. Studies have shown this close correlation. At the same time, active labor policies have not been at the center of our political action in the past few years, and therefore it is important to support the poor, but at the same time it is also important to state that work is the subject of very first article of the Italian Constitution. Italy is a republic that is founded on work. It is not only income, but also the very dignity of working, the dignity of kind of being able to produce, to generate income, to participate in the well-being of our nation with our own contribution. These elements have been at the very center of Italy. I mean, these aspects have enabled a country coming out of the Second World War to become one of the most industrialized countries in the world. So you can easily understand that this information related to difficult access to education, especially for poor families, and also of the fact that there is reduced focus on the dignity and importance of work, have to be at the center of our work. These are not only economic issues. Dignity means first and foremost that you have to find pleasure in your work, in the possibility to participate and build. The two things go hand in hand. I mean, conceiving work only as a performance, or the youth to live as one, or this agreed definition, or the idea that you're not satisfied and you continue to change. I mean, these two things show that there is a profound crisis in the meaning of work. After these preliminary remarks, I'd like to leave the floor to Silvana Sciarra. I'm sure she will delve into the legal aspects, the legal details of these aspects, and she can help us understand why a country like Italy, for which those who drafted the constitution in the first place focused on work as a very important country, actually is, in fact, as a matter of fact, an aspect that characterizes our whole country. Thank you. Thank you very much to the organizers for your kind invitation, for the invitation they extended to me on an occasion that has become increasingly central in the exchange of opinions, in the circulation of ideas. I'd like to tell you first and foremost that my greatest aspiration on such occasions is to kind of speak to the youngest, because it is with them, with a renewed spirit of initiative, one can reverse a style of communication which sometimes tends to be extremely too much based on rituals. Therefore, I particularly appreciate the stress that has been placed by this year's edition of the meeting on the third sector, on third sector organizations that help young people in difficulty, and of the kind of pining for their destiny. So those who are weak, the women. The theme of my speech reawakens a part that admittedly has never been dormant of my professional life. I've been a professor of labor law for many years. This was a passion for me. And my experience as a constitutional judge has once again kind of brought to my attention in asking myself for an even stronger coherence and asking myself to strike a new balance between theory and practice. Asking myself does not mean that I have succeeded in achieving this result. However, expressing this to you, expressing to you this constant internal tension of mine makes it possible for me to involve you in in a sharing of ideas that kind of touches our own emotions. And these emotions are very strong, even if one holds an institutional role like myself. After my years at the Constitutional Court, I have realized that within the flow of objective communication, and I stress the objective, what is important is not to interrupt our own path of growth as a person. Growth can, and indeed it must, be marked by reflections, doubts, and questions addressed to ourselves. As one always says on these occasions, I will speak in my personal capacity. I will not talk on behalf of the judges of the Constitutional Court that I have the honor to preside over. However, I cannot fail to say that I interpret the invitation addressed to me as a gesture of concern and attention for the Constitutional Court and for the constant work of the Constitutional Court in the defense of rights, because the Constitutional Court is a transparent and independent guarantee body. In this occasion, and I wish it with strong conviction, serves to establish a dialogue which I hope will be permanent, which will go well beyond my person, with the aspiration and the intention to involve the youngest in the context of paying respect to the institutions and to understand their work, because sometimes it's not very well known how they work. The collegiality of decision-making that characterizes the way that the Constitutional Court operates, this collegial decisions become a collective good. This collegiality of decision-making belongs to all of us. It is the expression of the impartiality that guides the judge. So respecting this decision-making model means grasping the value of our work, of a type of work that is oriented towards the striking of an advanced balance between democratic institutions. And this is basically what the Constitutional Court aspires to do every day. So now let's focus on work at the center of democracy, if you prefer, at the very heart of democracy. And what democracy? The democracy of the so-called moderns. In the words of a major scientist like Giovanni Sartori, as a distinguished scholar expert in democracy, who distinguished the democracy of the modern from that of the ancient. The one of the modern is founded on freedom and equality, and these are foundations that can, in a way, join and reinforce each other, but also dangerously disjoin. In the transition from one to the other, you have the constitutions, and with the constitutions you have the progressive emergence of the person, because the person, the individual, is a holder of both positive and negative freedoms. I always like to make reference to the philosopher Isaiah Berlin. He wrote a book on freedoms, and he focused a lot on this aspect of positive and negative freedoms. And Berlin interprets these principles as cornerstones of liberal democracy. So freedoms are, and I quote, freedom is, and I quote, the absence of obstacles to making potential choices. It's knowing which and how many doors are open, instead of wondering if and how far one wants to walk. End of quote. And it was precisely the metaphor of walking that was used by Pope Francis on the occasion of his recent meeting with young people in Portugal, With reference to work, I would like to suggest Pope Francis' invitation again. He invited young people in being perseverant in walking, in knowing how to walk towards a goal, and especially in learning how to get back up if you fall. Work is a journey of life, and that is why it lies at the very heart of democracy. I intentionally use the term heart as a vital organ, as a part of a body which is harmoniously built in order to function, to think, to love, and to establish relationships. In placing work at the heart of democracy, I am aware of the fact that work is not the only lever of change and of the advancement of social justice. Our appeals actually should be based in a society based on solidarity, in many communities based on affections, in friendship, which is so central. And these are basically the values that the whole of your debate gets inspiration from, not only in these days. So work, the work that our democratic republic is founded on. So work is the work of people, as individuals and as a community. And here too, the formula that the Foundation for Subsidiarity proposes, generation work, is very good. And I think that the work of an illustrious a member of the Constitutional Court, Mr. Mortati, who commented this first article, and he talked about the value of work, and I quote him because actually quoting their works are very, very important, because this basically makes up our mind. It's the necessary factor to the rebuilding of a new spiritual unity. Costantino Mortati, this is a nexus. This is some kind of a glue that brings together a necessary factor for the reconstitution of a new spiritual unity, a nexus, a link to hold together the social base, the prerequisite of the community state. And here I make reference to Article 4, because the right to work that society gives us is basically founded with the values of citizens, based on our possibilities and our choice in carrying out an activity or a function that contributes to the material or spiritual progress of society. So basically, according to our own individual choices, meaning according to our own inclinations, according to the ability that we perceive that we have or that we would like to achieve or that we have achieved. But oftentimes, actually, this combination between supply and demand in the work of labor is virtuously accomplished. And yet, in the European Union, 2023 has been called the Year of Skills, precisely to address this topic. Actually, this is a topic that the European Union frequently and cyclically presents. The aim of the EU has been to face the green transition and the potential job loss in some sectors that have been hit by the said green transition. At the European Social Summit that was held in Porto in 2021, we had to admit, it had to be admitted with some kind of self-criticism by the European institutions and national governments, that forms of social inclusion for the most fragile and vulnerable, for the long-term unemployed, for those with low professional qualifications, for those who wish to grow further because they work with non-standard contracts. And this continues to be lacking. The condition of prisoners is even more dramatic, as they are offered very few training and work opportunities. Just the court said of prison labor in one of its judgments that prison labor is an instrument of redemption, and the word redemption is very strong. The court said it's not a tool for the expiation of punishment, but rather it's a method of treatment. The protection of dignity is due for those deprived of their liberty. The training of adults as well as that of young people seeking their first job, if it is made deficient, if it is sporadic, because the bodies that are supposed to provide it cannot make it in fulfilling their intention, their objective, actually affects the duty of citizens to work, which Article 4 emphasizes against the right to work. This right, this is something that the Constitutional Court said and made clear several times, so this right does not coincide with the guarantee of job stability, but it is substantiated by the state's demand for active policies for support in the choice of that journey that I mentioned earlier. So basically work as a pathway, as a journey in life. In reading the articles of the Constitution that I mentioned, I think we must set aside some disenchantment because we might consider these provisions to be merely programmatic, so that they are not so much of use because it will be seen later on. But instead, we must believe with strong conviction that there is a project in these norms that is still valid and current, and that the social rights enshrined in our Constitution mark in a constantly topical manner the state's commitments to its citizens in an ever-timely manner. They are the expression of a democracy, as I've already said, of the democracy of the modern, and I would add a dynamic democracy. They are the link that binds together work and citizenship, and therefore they must be translated by politics into targeted action. And politics cannot but be prompted by citizens. Piero Calamandrei, another illustrious member of the committee who drafted the Constitution, wrote that when discussing doubts about the excessive generality of these articles, it was Palmiro Togliatti who urged his Florentine spirit, reminding of Dante. See, the members of the committee who drafted the Constitution, whom Calamandrei defines as those who prepare the Constitution, and this gives you an idea of this commitment in preparing the text. These people had to do, and I quote, like those who go by night, who carry the light beyond them and to themselves, and do not profit, but after themselves do the learned people. This is paraphrasing a canto of Purgatory, and the recognition in having illuminated the path is addressed to Virgil. So Virgil, masters, teachers like Virgil, educators, trainers, those who work in hospitals, those who work in social services, in prisons, those who help young people learn. These many Virgil play a crucial role in the democracy of the modern. Work enters ever-changing forms in terms of the ways in which it is performed, in the places and the times in which it takes place. And then to mention Sartori again, in the democracy of the ancient, conversely, slaves awaited work. And even modern representative democracies know forms of forced labor. In modern representative democracies, forms of control of power are developed in order to limit power. And civil society, understood as a pre-political society, as an autonomous and self-sufficient sphere, unfolds as such. In labor, in work, in the many universes that characterize the evolution of work, the democratic principles of representation and the protection of the autonomy of collective subjects burst onto the scene after the corporatist period, and they become essential cornerstones of a dense system of rules, and that's the very core of our democracy. So the formula popular sovereignty stimulated the critical spirit of another member of the same committee who drafted people who drafted the Constitution, Luigi Eunadi, who placed it among the concepts that are called myths, which are in essence empirical formulas acceptable in view of certain purposes. It is precisely this empiricism, this is a very evocative use of the term by Einaudi, so this empiricism when it is linked to the centrality of labor in the democratic structure of the Republic, this empiricism allows us to visit a world that is inhabited by great and original novelties. Workers' representation develops in parallel with political representation, although I know that it is different from that. Let's read the first paragraph of Article 39 that's very dear to labor legal experts. The trade unions must be freely established. The trade unions, no longer constrained within the confines of a repressive regime for individual freedoms. I talked about positive and negative freedoms before. Now we have the freedom to join or not to join trade unions. And this becomes the expression of a democracy which is in motion. In the persistent non-implementation of the paragraphs following paragraph 1 of Article 39. So trade unions act as an unrecognized association, so as an intermediate body. This term is very dear in the studies produced by Professor Vittadini. And it is an intermediate body that expresses collective aspirations to be translated into rights, that strives to build consensus, that has recourse to conflict as an instrument of self-defense in pathological situations when the natural and physiological exchange of negotiations is interrupted. The purely voluntary collective bargaining, we have collective bargaining, but we're not alone on that. In many Northern European countries, there is some kind of resistance to the fact that the lawmaker intervenes. So we have a purely voluntary collective bargaining on the one hand, and on the other hand, we have the only sectoral intervention of the legislator in implementing Article 4 in regulating the exercise of the right to strike. So all of this has contributed to making the Italian system as a very original one in a comparative framework. At the CNEL, approximately 1,000 collective agreements are filed with the CNEL, with different scopes of effectiveness and stipulated at different levels, including the company level, which is a very important level in the history of Italian collective bargaining. This is a great heritage. It is the product of collective autonomy. It involves subjects that are representatives of both workers and employers. The method followed by the great reformers of labor law, among them we have Gino Giugni, he was my master. This method made it possible to affirm at the dawn of the 1970s, when the support legislation began with the workers' statute, this made it possible to affirm that the trade union, in detaching itself from the state individual that was identified with the constitutional system, is still part of that system, even in absence of a full implementation of Article 39 of the Italian Constitution in paragraphs 2 and following. So a trade union pluralism, therefore, is shaped in Italy that expands and strengthens the first paragraph, that is trade union freedom. Trade union freedom marks a decisive step in the settling of our democracy after the ruins of the Second World War. Even for trade unions, the principle of independence and thus of total otherness with respect to those who exercise organizational and managerial powers in the workplace. The trade union representativeness specifies the Constitutional Court is detached from any recognition by the employer expressed in a factual form. So basically, the court is saying that trade union representativeness is not negotiable. The trade union, the employer cannot interfere. That freedom, like the other freedoms guaranteed by our fundamental charter, cannot be compressed also by virtue of the compliance with the obligations assumed by our country in international fora due to Article 35 of the Constitution. I would like to emphasize this point because this norm is particularly far-sighted. The Italian democracy has, since its inception, been very permeable and very receptive to international standards since its origins. The first ILO conventions date back to this period, then the European Commission for Human Rights, and then later European sources. So in this way, inside the Italian law system, a synthesis is implemented that tends to maximize protection, thereby enhancing national peculiarities. These are never forgotten. And these synergies are, in my view, essential in the times we live in, because in these times, value chains are global ones. And therefore, labor demands protection in all the rings of these global chains. In this reference framework that aims at increasing the vitality and the strength of our Constitution by giving new depth to the exercise of vitality and strength to the Constitution, we go back to Giorgio Vittadini's invitation to go back to the living subsidiarity. I mean, the data you were mentioning before are food for thought. And the meetings taking place here in Rimini, and also a wonderful exhibition today, show that we must not stop searching for the spirituality of the constituents, that is to say, of those who drafted the Constitution. And this is stated in a wonderful book by Cardinal Matteo Zuppi and Valerio Onida, President Emeritus of the Constitutional Court, in a recent book. So they talked about spirituality of these people as a deep sharing towards concrete goals. Let us try to list some of these objectives, putting the person at the center of our occasion. For some time now, the terminology of European labor lawyers has, and not only Italian ones, but European labor lawyers, have started using the expression personal labor relations, which in a way tends to leave the classic distinction between self-employed and subordinate work in the background, in view of the fact that the contemporary reality of work makes the borderline between these two types of contract increasingly thin. As I said before, the members of the committee who drafted our constitution were very far-sighted back then in drafting Article 35. The Republic shall protect work in all its form and applications. It provides for the training and professional advancement of workers. The language of scholars, jurists, and social scientists is in search of formulas capable of grasping the novelties of the present, and therefore the talk is about labor constitutions, which kind of insinuate common rules of democracy in non-traditional labor contexts, which are nonetheless characterized by homogeneity of performance. So there is homogeneity of performance in spite of the fact that the traditional characteristics of subordinate work are decreasing. So labor constitutions. So this plural form makes us think of a dissemination of constitutional principles in realities which are only apparently peripheral to work, to labor, but they are a sort of adaptation to the Constitution to new labor realities.
So this is happening. So apart from some data and some incredible articles that have been published recently on bad practices in this context, labor law and with it the action of collective subjects is gradually converting protections, orienting them towards change in organizational formulas. And in this modular process, workers, as persons, people, must have access to fundamental rights, both individual and collective, regardless of the type of contract that they entered into with their employer. And I'm pleased to say that the Court of Justice of the European Union made this objective its own in a recent ruling, a ruling that was issued following preliminary reference coming from a Polish judge. And the Court of Justice stated that for reasons of social and public interest, this is important to underline, the legal form under which work is provided must be disregarded if obstacles based on discriminatory grounds, in this case sexual orientation, are to be removed. And the court said that the cancellation of work shifts, and this is a non-subordinate kind of work. Well, the court talked about personnel or an activity that, personal employment, an activity that is carried out personally. And so in this case, the situation is equivalent to dismissal. So it was, it appeared to be an independent work, whereas it was a personal employment relationship. So subordinate employment keeps on representing a point of reference. And in order to draw the weaker party into consolidated area of protection, a self-employed worker who is unable to take upon himself or herself the risks of an activity, becoming economically dependent on a main client or principal, is into a bubble of false autonomy and may be considered as weak. But what about if the employer is an algorithm? There are colleagues studying these kinds of things, and they are smiling. Well, you know, control is exercised, and has been since the Second Industrial Revolution, by employers. And in the gig economy, control is entrusted to platforms, and it often takes on more penetrating characteristics. People tend to talk about contractual distancing, which describes reality very well. And this distancing is due to the absence of a traditional workplace. Remember, a gate to pass through, as the symbolism of big industry reminds us, which is also linked to the impossibility for these workers of observing traditional working hours, because I get in, get out. No, there's just a platform, and this can lead to new forms of alienation and social marginalization. So are these jobs at the heart of democracy? I wondered while I was drafting these notes for this meeting. Well, I suppose that we should reflect upon this. But there is an important signal coming from Europe, because there is a proposal for a directive on which the European labor ministers expressed a common position quite recently in June. So we hope to have this consensus. Well, this new proposal suggests, when dealing with the digital platforms, that the employer has to prove the non-existence of a subordination moment. And so the directive leads to a sort of presumption of subordination if at least two criteria can be found, as the directive says. For example, the determination of a certain level of remuneration, which is a classical criterion, or precise obligations of conduct towards the user, in this case because the worker, in case of platforms, responds to users, but it's actually the platform setting the limits. So a series of ways to control the execution of work and limit the kind of work carried out autonomously, independently, even for the purpose of building up one's own clientele. So according to the director, there must be at least these two criteria. They must be fulfilled. So the solution proposed is interesting because, quite innovatively, it draws on the on protection techniques that were traditionally adopted, not only in Italy, but in many of the democratic countries, to correct the weak position of the employees in the employment contract, because there is an asymmetry between the two contracts, and there is the same symmetry also in the gig economy. Luckily, in Italy, there are several indications given by the law on this kind of work relationships. But it is important to underline that in 2020, the Italian Supreme Court chose to enhance the protection of riders. Riders on the basis of factual data, you see. Once again, we talk about the personality of the service or the continuity, the indications transmitted through the platform. And so these should conform, should be conforming, let's say, the service and to the rules that are independent of autonomous choices of individuals. So it is the riders who, at the center of the court's decisions, even important decisions, well, they are at the center because their silent presence during the pandemic. You know, you remember their bicycles going around empty, silent streets. Well, their presence visually marked our memories and really brought out the importance of a job that was only apparently marginal, because it was crucial, essential to, you know, deliver food, to deliver drugs in those terrible days. But there is even more. There is an empirical research identifying geographies of work platforms which are tactically organized locally, regionally, and globally, and which tend to converge. It is a phenomenon which is well known by the organizations of enterprises, for example. So they tend to converge at the center of the control exercised by algorithms. And sometimes they're in positions which are far removed from, far away from the workers. So the spatial dislocation, which can give rise to inequalities in salary treatments in different parts of the world, as well as to discriminations. Well, and also the mobilization of workers who demand to balance information asymmetries with transparent practices, with a sort of, you know, collective reaction. Well, this is a reaction to a word that is called and defined management of algorithms. You see, these new expressions enriching our language. And this calls into question, among others, international organizations. Furthermore, there are several reactions from national courts which are all heading towards the recognition of the subordinate nature of the services offered through platforms, in particular with the reference to riders, but not only. It is clear that this opens the way, paves the way for the intervention of collective bargaining, which is also beginning to spread in this kind of situations. And in Italy, Italy is among the countries where recourse to collective bargaining is already widespread, and there are several cases. And then Spain, but also Netherlands, Portugal. Well, in those countries, the percentage of workers employed through platforms and those who have this as their main occupation is increasing. And so in Spain, we can remark that not only the high percentage of the active population is emphasized, but also the economic relevance of the kind of work activity carried out is underlined. And all of this leads us to reflect not only on the opportunities for the progressive extension of protections, but also on the opportunity for a new normality of digital subordination to emerge. And I said new normality because it should be marked by a controlled flexibility and with tools for inclusion and continuous training, inspired by the respect of the principles of freedom and equality, which are the basis of the democracy of the modern. And above all, capable of combating all forms of discrimination, hidden behind the apparent neutrality of algorithms. And there are several data confirming this. So the reflections that I've talked about so far cannot disregard another thing which sometimes is intertwined with the platform work and that sometimes we tend to set aside. And I'm referring to artificial intelligence, which is the subject, inter alia, of a recent proposal for regulation of the European Parliament and of the Council, which describes a model of responsible innovation, so restrictive of certain freedoms, because there are some freedoms that might be reduced. But this is done according to strict criterion of proportionality and in order to ensure the protection of fundamental rights, among them health and safety. So AI providers have enormous responsibilities because they have to inform, as the European Commission says, the competent national authorities and, know very well these rights. So it is a very complex and thorny aspect, and I don't want to dwell too much upon it. But AI is involved in those kinds of work, and can we pretend that AI is at the heart of democracy? Think of the robot which lifts heavy objects in large companies dedicated to the delivery of goods to people's homes. Well, does this robot help the human beings who roam around the shelves and have other manual tasks such as packaging the goods? Well, is there this kind of help? Because here we get to the digital Taylorism for, let's say, the those who have a higher age, let's say, as I have. This kind of Taylorism is something that is quite known because it was something that was related to the repetitiveness of work, of tasks, tight rhythms, and little interaction with other workers. And so, considering this, we enter a more inductive knowledge where the work is based on information coming from machines or digital tools. And I think that we will have to reflect a lot on this, also labor experts. So let me move to the conclusions of my remarks. I said that labor is both the engine or driver and the user of democratic rules. I say engine because with its rules and with the affirmation of freedom and fundamental rights, it has really underpinned democracy, a democracy that had arrived after an authoritarian regime. And user because it has induced the legislator to transfer constitutional rights to the workplace, limiting powers exercised arbitrarily and affirming the value of the dignity of work, as we underlined in the introduction. So along this journey, this path, the Constitutional Court has marked some milestones because alongside the right to work and Article 4, Paragraph 1, it underlined the protection of work, Article 35, correcting imbalances that can emerge in employment contracts. In employment contracts more than in other contracts of duration, and because there is a strong involvement of the human being, more in employment contracts than in other kinds of contracts. And as Martha Nussbaum in her theory of fundamental rights said, there are a set of capacities or possibilities operating. And so inequalities are accentuated if one starts out disadvantaged in life and does not seek corrective support or points of support, some levers to grow and affirm oneself as an equal. In democratic countries, constitutional courts seek a balance and are aware of the reflections on freedom and equality. And so two steering wheels, or two rudders, if you want, are needed to, steer constitutionalism towards the freedom of the modern. So the two rudders are equality and reasonableness. But, constitutional judges should stop at the boundary of the legislator's discretion. And its task is to remove the obstacles that prevent any imbalance from being corrected. But beyond that boundary, modern democracy demands answers. So my wish, which is addressed especially to the youngest and to those who work in bodies in the civil society, is to convey a spirit of responsibility and trust in institutions in order to help encourage them and increase their visibility, because they need to be encouraged. Human existence is an inexhaustible friendship. Well, this title is wonderful, and I hope that it will be followed by more tangible actions that you carry out every day in your work and in your lives. So I wish you a very fruitful meeting, and thank you very much once again for inviting me.
L'applauso segna il consenso profondo che se...
Well, as we can hear, there is a very deep, consensus in a way, because we generally have to create work and economic elements. But, if we don't have a profound connection, a deep connection with principles, with ideals, everything becomes pragmatism, which kills the chance to build something over time. And there are two principles that the President mentioned. The first article of the Constitution that she commented on, starting with Calamandrei and the other experts, well, she said that there was something deep, something huge. Father Giussani talked about work and not about, social meetings, but about spiritual exercises. And it was fundamental that everyone could work. And it's exactly the same spirit, the same idea that is in the Constitution. So the President, Professor Sciarra, talked about this, the fact that everyone should have a job, and a decent job, ensuring a decent life. And the second principle is that this should become the norm, should become something protected. But at the same time, it should be flexible because there are several situations, several kinds of realities, and AI is also involved. So I think that we should bear in mind these two main points and consider the, centrality, the importance of work. Think of Italians that used to emigrate in the past looking for a job, and the many migrants that are arriving now in the search of a job. And so these 2 points are fundamental and are at the basis of all of this. And so I would like to thank you for mentioning them. Thank you for your presence once again, and I hope that there will be other chances. Thank you.
Civiltà dell'amore, fratelli e sorelle, costruite senza stancarvi mai questa civiltà. Lavorate per questo, pregate per questo, soffrite per questo.
Da un'idea di Giorgio Vittadini, un laboratorio di ricerca, formazione, divulgazione per promuovere la cultura della sussidiarietà, motore di democrazia e sviluppo sostenibile. Fondazione per la Sussidiarietà, da 20 anni, un network che crea consapevolezza e partecipazione per il bene comune.
Dieci racconti di solidarietà e aiuto concreto. Storie ricche d'amore, riscatto, coraggio e cura. Storie di persone che donano e che ispirano a costruire una società inclusiva. Una mano a chi sostiene. Storie.
Il senso religioso o l'esperienza religiosa è innanzitutto un fatto, un fenomeno obiettivo, un fatto reale, non è un'idea, innanzitutto non è un modo di sentire, non solo si tratta di un fatto, di un avvenimento, ma del fatto più imponente e più inestirpabile della storia dell'uomo. Più imponente, più vasto, che neanche il fenomeno dell'amore dell'uomo e della donna, che neanche il fenomeno del rapporto tra genitori e figli. Perché il senso religioso è un avvenimento che pone, che afferma o che ricerca l'orizzonte entro il quale acquisti senso anche il rapporto tra l'uomo e la donna, anche il rapporto tra genitori e figli. Perciò è più vasto, perfino di quelli.
A una O che divide, preferiamo una E che unisce. Per per sostenere il presente e il domani di tutto il paese. E lo facciamo da 70 anni. Eni, l'energia di sempre e l'energia nuova.
Quello che ti serve quando ti serve. Nasce Easy Bank, la nuova banca digitale di Intesa San Paolo. Easy Bank, semplicemente banca.